I would like to begin now. We have many people in the room, in the Zoom room, and others will be joining us, but because we have 1 hour, I would like us to begin now. Hello to everyone who is Zooming in and to our special guests, Brina Smith and Morgane Micot. My name is Kate Quinn and I'm the co-chair of Edmonton's Sexual Exploitation Working Group. We are situated in our Week of Awareness in Edmonton. It is also the Provincial Week of Awareness of Sexual Violence, and it is our National Week of Awareness of Victims and Survivors of Crime. So a very auspicious week. Let us begin by acknowledging that those of us who are Zooming in from Canada, we are all on the traditional territories of the First Nations, Inuit, and Métis communities. In Canada, we are in a historical time of confronting the truths and the impacts of colonization, especially the intergenerational impact of the residential school system. You will see that I am wearing orange and I have an orange t-shirt in the background, as well as a red one. We have chosen the color orange for Sexual Exploitation Awareness Week for over 18 years now. But we also join with the Indigenous communities across our land who have brought forward the color orange to remember the victims and survivors of the residential schools. We know that every child matters. Many families and communities are in mourning in our country as we continue to uncover the unmarked graves of children who were in the residential schools. Today, let us be mindful that we are all treaty people and that we are all called upon to work to reconcile and to heal the harms that have occurred in our land. The role of our education working group is to create learning opportunities for the public. We are a leadership group comprised of community, government, and law enforcement stakeholders. Our topic today focuses on human trafficking for sexual exploitation and exploring vulnerabilities and criminalization. Our two guest speakers are Morgane Micot and Brina Smith. There will be time for a question and answer after they speak. I invite you to type your questions at any time during their presentations and add whether they are for Morgane or Micot. The questions will only be seen by two of our working group members, and they will group them together and present them after Morgane and Brina speak. The chat function is disabled. I heard Morgane speak at a virtual conference, European conference sponsored by the Office for Democratic Institutions and Human Rights. I was very intrigued by her presentation and I wanted more people to hear her thoughts. So she generously agreed to come to our webinar, which is noon in Mountain Daylight Time, and she is in Vienna. It's after 8 p.m. there. So we're very thankful to you, Morgane. She is a legal expert specialized in criminal justice and protection issues. Morgane leads the knowledge development and innovation team in the human trafficking and migrant smuggling section of the United Nations Office of Organized Crime and Drugs. And she advises many countries and stakeholders and trains criminal justice system practitioners. I'm really pleased that Brina Smith can join us. She is an Alberta Crown prosecutor and has served for over 12 years in this role. Her first 10 were spent in the Edmonton office with a focus on prosecuting crimes, including sexual violence against adults and children. She is now working in the organized crime unit in the Edmonton Specialized Prosecution Branch. I'm also proud to say that Brina has served on our board of directors for 6 years. So welcome to you both, and we will begin with Morgane.
Thank you very much, Kate. It's a pleasure for me to be with you on this special occasion today. And I would like to thank you for actually giving the opportunity to an international organization to give the perspective on especially trafficking in persons and the issues around it. I am kindly asking Clayton to share my presentation, given that I'm not so tech savvy. Thank you so much. I will be in the next minutes talking to you about first the international framework and touching upon very briefly how it relates to the Canadian one. Then we look at some of the general trends so that you can have a perspective of what's happening in Canada versus the rest of the world, how it can compare. And then I'd like to move into something that's specifically related to vulnerability and the forms of means which are used to nullify the consent of victims of trafficking. Why and how is the exploitation happening in their case, and potentially what could be done once we acknowledge that to better protect victims and stop impunity against trafficking in persons. So here on the screen, you have what is trafficking in persons according to the international framework. Maybe I should remind you that 178 states, member states of the UN, have agreed to that definition and have agreed to criminalize this conduct specifically. So in addition to other criminal offenses that have pre-existed, such as slavery, for example, trafficking in persons captures a broader scope of conduct, and in that sense is very important because it allows to go after those that don't necessarily exploit themselves, but all those who have been instrumental in making the exploitation happen. So that's why you have here on the screen, you have three elements that are essential in international law when it comes to trafficking in persons. You have an act, and the act can be recruitment, transport, transfer, harboring, or receipt. It can be any of these acts. It doesn't need to be and. You can only prove one of these acts, for example, the recruitment of a person. The means, the trafficking must have been committed by the following means, which are the use of force or the threat of the use of force, coercion, abduction, but also some more subtle means such as deception, abuse of power, or abuse of vulnerability, which is a specific means I'll touch upon later on. And finally, all of this needs to have been done intentionally for the purpose of exploiting the person. And the list here is a minimum for states to respect, but of course they can include other forms of exploitation. So at a minimum, it needs to be exploitation of the prostitution of others, other forms of exploitation, forced labor, slavery, or practices similar to slavery, or trafficking for the exploitation of the removal of organs. And here I'm just doing a little parenthesis. Removal of organs is different from organ trafficking. Organ trafficking is just about the organs, while here we're talking about an act and the means being used for the purpose of, for example, removing a kidney from a person. So all of this needs to be brought together and evidenced, which is not always that easy, especially when it comes to the means that are used in relation to the consent of the person. Now, a very, very important exception is that when it comes to children, those means are not relevant. They're not relevant because it's the issue of consent of children. Hence, in that situation, you don't need to prove any of these means were used in order to get to the exploitation of the child. Now I'll move to the next slide, and I won't be spending time on it because, of course, we have our expert Brina with us on Canadian and Alberta law. But I just wanted to do a very quick comparison with the framework that you know in your country and in Alberta. If Clayton, you could please go to the next slide. So, on the basis of what I know, your criminal code is actually defining trafficking in person in a way that's slightly different from the international definition. It adds a few acts which are holding and concealing, in addition to those that are listed. And in terms of means, it's mentioned slightly differently, like it's mentioning the exercise of control, direction, or influence over the movement of a person. As a result, the type of evidence that needs to be brought is slightly different. However, the issue of consent remains absolutely central to building a case of trafficking in persons. And I also wanted to use the opportunity to highlight the Alberta Protecting Survivor of Human Trafficking Act, which itself is actually very much aligned with the international definition I just presented to you. So actually locally, you do have the same elements with this addition of the two additional acts, as well as, and that's actually a very good addition of a means that can be used, which is the provision of a controlled substance, which indeed is happening on many occasions. You also have at the very end, in terms of the exploitation types, you can have also the exploitation that relates to the removal of not only organs, but also tissues, which also absolutely makes sense. So passing on to the next slide, now that I've covered that, here I just wanted to have a snapshot of how it differs from one region to another. And you see that on the whole of the American continent, the most detected forms of trafficking, and I'm saying detected, that's what the authorities see, report, which offenders the charging with. It's sexual exploitation, trafficking for sexual exploitation, and mostly concerning victims who are women, as well as girls for Central America. And you see that the picture is different in other regions. There may be many reasons for that, but I think it's interesting to note that. And I don't want to spend too much time on it, but I invite you to refer to the global report on trafficking in persons that UNODC publishes every 2 years, which has all this information in details as well, region by region. And we'll go to the next slide, which shows exactly for North America, the share of women, adults and children detected by the authorities. So for North America, we see that women are by far the group that's the most detected. Children are not that affected according to the detection by the authorities, which is actually lower than the global figures. But here you still see that female victims are really disproportionately detected here. And that is directly correlating to the fact that it's sexual exploitation. That's the most detected type of exploitation, which you see on the right-hand side of the slide as well. Maybe moving on to the next slide. Oh yes, and just mentioning that gender is, I mean, trafficking in persons is a very gendered crime, and that really shows from this slide. Forced labor is usually the type of exploitation that would be most detected for men, in some regions for children also, much less than sexual exploitation. But we've seen with time that there's been an evolution there as well in the capacity of the authorities to detect various types of exploitation, as well as various types of victims. So moving on to the next one, also a snapshot of where do the victims come from. And please note that in North America, most of the trafficking is domestic. And I know that in Canada, that's really clearly confirmed, which is really not the case in all the regions. And apart from domestic victims, you will see that a small percentage of the victims come from the Asian region, while a smaller percentage come from the rest of the continent. Again, you can have more information in our global report if you'd like more details on that. So moving on now to the last slide on the trends that would actually be a good opening for the second part of my presentation, which will be a little bit more technical. Here you see the share of convicted persons, and globally you see that yes, men are widely more represented among offenders than women are, but when you compare the share of women on trafficking charges to the share of women for other types of serious crimes around the world, it's really by far much higher than it is for other forms of crime. So, I mean, on the right-hand side, you see that for North America, let's say that the ratio may be a little bit more aligned with the other forms of crime, but globally, there's really a huge, much higher level of women offenders in trafficking cases than for other forms of crime, serious crimes. Moving on, now that we've established that, we were thinking, why is that? How come? What can explain the fact that women are so represented in those cases? And that led to this study, which we called Female Victims of Trafficking for Sexual Exploitation as Defendants. Sorry, I'm going back to the previous slide. You can find the study in on also our website. If we could please go back to the previous slide. Yes, so it's a the one with the publication. So the following one, in the other direction, slide number 7. Yes, thank you. So this has been done on the basis of case law analysis, case law that we've collected, as well as case law we already had in our database, because we are looking into judicial practice. And I'm just going to pick a case study here that is on the right-hand side. Sorry, maybe there's a timer on the thing. It's not supposed to be. Maybe we can pause it so that we have time to have a look at the case study. The case study is actually about a very young offender or woman who was charged with trafficking offenses together with a man. And they were charged with the forced prostitution of 2 minor girls who were aged 14 and 16. The offender, who I call Alicia, that was not her real name, was 18 years old at the time of the events. And she had actually instructed one of the victims on how to dress and what to do with clients. And she had taken the phone away from the other victim so that she wouldn't escape. At that same time, Alicia was also being sexually exploited by the trafficker, but she thought she was in love with him. She thought they had a relationship. And when we dig into her previous experience, actually, just a few weeks before, or months before, she was a minor being into sex work. She had become an adult rather recently. She had run away from home. She had been repeatedly abused sexually in her childhood. And also physically abused. She developed substance abuse problems, and as a result, she also developed mental health, serious mental health issues, including PTSD that she suffered from at the moment of the events. So you see that it's unfortunately quite a typical story, but there's plenty of elements here that would make someone click, thinking, okay, there's something about the story of this girl which makes it important to consider maybe some mitigation or more in her case, and understand how she came to inflict this to these other girls who were children. So moving on to the next slide, what I wanted to flag is that it's actually a study that's based on a Canadian case from Ontario, where the court, actually the charges were not on the Trafficking Act, but they were on ping, basically benefiting financially from prostitution of others. But it's the reasoning that interested us here, is that the court recognized that at the time of the offense, Alicia was under the control of the trafficker, and that she was physically and emotionally abused by him. And as quote here, she had been victimized as a child sex worker. She suffered trauma as a young person, and she suffered from PTSD. So as a result, she had a mitigated sentence. She got the minimum 8 months imprisonment, while the trafficker, the main trafficker, the male, got sentenced to 4 years imprisonment. And this actually pretty much sums up some of the conclusions we've made from this analysis of case law across the world, is that traffickers use victims to shield themselves from prosecution, and so that they can enjoy impunity. And we saw that the control methods were very similar in these cases than those that we could see in domestic violence and intimate partner violence. But we also saw that the courts were very reluctant to look into that. Usually they would not look into the relationship between the co-traffickers, let's say in that case. And there was in her story really a normalization of violence. She really was subjected to multiple forms of violence, including from early childhood, that made her potentially not question what she was engaging in, given that she had been subjected to that repeatedly for a very long time. And now what we also saw is that actually there are very much fewer cases of women engaging in trafficking offenses to alleviate themselves from the trafficking itself, to free themselves and to gain more money and a better position in the organization, than they are victims who continue being exploited and victimized while they are exploiting others or helping the trafficker exploiting the victims. So we found it very interesting as well. So this led us, and that's the next slide, which I think is the last one before Brina takes over, to look at vulnerable persons. I mentioned earlier on the issue of consent and the issue of abuse of a position of vulnerability, which is very difficult to prove. And what we've seen is that very often practitioners look at the vulnerability of the person and want to jump into concluding that then there was abuse of a position of vulnerability, which would not be enough in court, because you need to prove that the position of vulnerability was abused. So what was the motives of the perpetrators? That's really what needs to be considered. So first, that there was some vulnerability, which here I exposed. There are different forms of them. It's not defined in international law, but it can be personal, it can be circumstantial, it can be pre-existing or created. So you need to take that into account. And substance abuse, for example, creates vulnerability. Being running away from home also creates vulnerability, among other things. And then the abuse of a position of vulnerability, as you see here, is like really the intention to exploit that vulnerability, take advantage of it while you're committing any of the acts that are presented to you, and at the end on the exploitation as well. And what happens is that the victim is convinced that this is the only way they have, that almost the trafficker is saving them from a situation that is worse than what is being offered to them. And that's really what it entails. And of course, what needs to be assessed as well in those cases is whether this belief is credible from the perspective of the victim, of course. So here, when these means are being used, then the consent of the victim is nullified, is vitiated. So that's important also, because then you have your trafficking case that's established. And this is for this type of circumstances, this type of cases, that the international community more and more is talking about non-criminalization or non-punishment of victims of trafficking who have committed crimes while they were being exploited. Of course, that's not something that's in international law per se, but the doctrine in French, the policy and the practice more and more shows that if this is not taken into account properly in the criminal justice system, then most likely the protection for victims is failing them. It's not happening. If they end up in jail for crimes they committed under the control of the trafficker, then something really did not work in the system. So one way to do that, to also address that, given that victims of trafficking are often, I mean, in those type of cases, often in denial, they don't see themselves as victims, is to see if there could be alternative ways, alternative evidence to avoid victim testimonies that you may not be able to secure in those cases. So really relying on expert insight, and that can be cooperating with experts such as psychologists, social workers, anthropologists, cultural advisors at the investigation phase for an effective and appropriate evidence collection, as well as at the prosecution phase, which would be with expert witness testimony, as well as supporting the victims through the trial process. And that really could be a game changer. And I will stop there. Thank you so much for your attention and the opportunity.
Thank you very much, Morgane. And now over to you, Brina.
Thank you, everyone. And I appreciate and I'm honored to appear today. Morgane called me an expert in this area, so I want to be very clear. I wouldn't necessarily call myself that, and a number of my colleagues online, I believe, would also be more qualified. But we, in our office in specialized prosecutions, deal with these human trafficking files. We have now recently began work with the ALERT teams, which is the human trafficking counter exploitation unit, which is now providing and investigating these files, which we are now working with that unit as well as other law enforcement agencies throughout Alberta in prosecuting these types of files. When we are seeing what we have seen, much of that is coming through the lens and what we can do from the prosecution's perspective, but exploitation, sexual exploitation, these types of offenses have a wide range throughout our criminal code, but I'm going to focus mostly on the human trafficking aspect of it, and that, and also touch briefly on the law within Canada. Some of the newer provisions that came in after the landmark decision in Bedford from the Supreme Court of Canada that address some of the sex trade work offenses that overlap in similarities in relation to the definitions. But we are just going to focus on the human trafficking law and as it stands, and just address some of the definitions and the law as it stands in Canada currently. And I'm going to try and share my screen. So in relation to this screen as it is, I think it's moving. There we go. The Criminal Code of Canada, as mentioned by Morgane, the main human trafficking section, it falls under section 279.01. There is also this is in relation to any victim. In relation to an underage victim of under the age of 18 years old, 279.011 captures trafficking of a person under the age of 18. But in relation to the trafficking of persons under this offense, as stated by Morgane, there are different ways in which one can commit this offense in the act part of it. But the elements of human trafficking as they are is that it's made out where an accused recruits, transports, transfers, receives, holds, conceals, or harbors a person, and as indicated, or exercises control, direction, or influence over the movements of a person. So that's the action part of the offense. When we look to the mental element that is required to be proven, we have to prove that the accused intentionally engaged in that conduct and that it was for the purpose of exploiting the person or for the purpose of facilitating their exploitation. So the central element of the human trafficking offense in Canada is the criminalization of exploitation. So the acts, as mentioned, are only a crime if they are committed for the purpose of exploiting or facilitating the exploitation of that purpose. And what it's noteworthy is subsection 2 of that section is that no consent to the activity that forms the subject matter of the charge is valid, which means that if a person is found to be exploited or the purpose of the actions of the accused is in fact facilitating their exploitation or is exploitation, the consent of the person involved being the victim is not relevant and not a defense for the accused. Obviously, there are different concerns and interplay between relationships that can be formed through the exploitation of a victim. And we can see that play out, unfortunately, through the court process and the investigation process. But it is important to realize no matter the age of the complainant, a person cannot consent to being exploited. And that is as it stands in the criminal code now. In relation to the definition of exploitation, what is exploitation? What we are looking at in Canada, An accused person will exploit another person if they cause them to provide or offer to provide labor or a service by engaging in conduct that in all circumstances could reasonably be expected to cause another person to believe that their safety or the safety of a person known to them would be threatened if they fail to provide or offer to provide that labor or service. When we look to this section, they look to the factors in subsection 2 to determine whether the actions are exploitation. And they may consider, among other factors, they've outlined 3 there, that force was used or threatened, or another form of coercion was used, or that they used deception, or abused a position, trust, power, or authority. And here, when we look to the definition of exploitation, safety is not limited to a person's physical safety or physical harm of that person. It extends to the psychological harm of that person. So what damage is looked at and the harm being posed to the victim is not limited just to that physical harm. Another important aspect of looking at exploitation and the definition and how we in Canadian law define it and is that it is an objective test. As you can see there, an objective test means a reasonable person test, that what would a reasonable person look at the situation and conclude. And when we see that, that reasonable person test or the objective test is used to assess the actions leading to the exploitation. So this means that it's not just a focus on the complainant and what the victim believes to have happened in the offenses or the actions taken by the accused. And while their beliefs in what occurred will be considered, it's an error to focus solely on their testimony and their subjective perceptions about what the situation was, what the relationship was, and what the circumstances surrounding the offense were. So for instance, if there is evidence about assaultive conduct or threatening conduct or other type of objectively exploitative conduct that was taken by the accused against the victim during this time, that it could still lead to a finding of exploitation, regardless of whether the complainant themselves believe they were being exploited. So it's important to consider that that objective test is how we view this, and the Ontario Court of Appeal looked at that factor in Regina and AA in 2015. So then looking to other factors that we would consider as to whether or not a person is exploited in the human trafficking offense, the decision of Sinclair from the Ontario Court of Appeal in 2020 outlined a number of factors that the courts should consider as to whether or not a relationship or the circumstances of an offense amount to exploitation of the complainant. As you can see there on the screen, the presence or absence of violence or threats, but it's also considered whether there are coercion, including physical, emotional, and psychological. They look to deception, the abuse of power or trust or authority, and that's what we see in the actual criminal code, but they outline a number of other types of factors to consider. Vulnerability due to the age or personal circumstances of the complainant, such as their social or economic disadvantage and the victimization from another source for that complainant. The isolation of the complainant, for instance, if they are taken away from families or communities and brought to places they don't know where they are, don't have contact with their families or friends. The relationship between the accused and the complainant is also looked at. Directive behavior or influence that's exercised over the nature and the locations of the services provided by the victim. There is also a look at control over advertising and services, the limitations on the complainant's movement, control of their finances, as well as the financial benefit to the accused, and looking more and more to the use of social media to assert control or monitoring communications with others. So those are not an exhaustive list of factors, but it is a list that look to whether or not a relationship or the offenses being committed would amount to exploitation. And as stated, that 279.01 is focused on whether or not the actions carried out were for the purpose of facilitating the person's exploitation or exploiting them. And in that section, actual exploitation is not necessarily an element. If that is the purpose of the accused and the actions he's taken, that is in fact enough to prove that charge. The one part I did want to mention, which is a recent addition to the section, it was originally introduced by Bill C-38 in 2017, but it didn't actually come into force until June of 2019 under Bill C-75, sorry. And this is a presumption that has been created under this section, which is for both this section being 279.01 and the underage section of trafficking an underage complainant. It creates a statutory presumption that evidence that a person who is not exploited, being the accused, or someone else, lives with or is habitually in the company of a person who is exploited, in the absence of evidence to the contrary, is proof that the person exercises control, direction, or influence over the movements of that person for the purpose of exploiting them or facilitating their exploitation. So this is actually, in Canadian law, a recent amendment that in fact shifts the onus from the prosecution. And once we are able to provide evidence, such as the fact that the complainant was living with or habitually in the company of someone else who was not being exploited, that would actually be proof of the control or direction and the influence needed to prove that this was for the purpose of exploiting them or facilitating their exploitation. And it would shift that burden then to the accused to provide evidence to the contrary, that that was not in fact the reason that that was happening. The stated purpose of this presumption was in fact to try to reduce the need for the victim to come to court and testify. As many of us know, the weight of these types of investigations and prosecutions can often rest on the complainant in needing their testimony to come to court and tell us what happened. I don't necessarily think that this would alleviate that altogether, as they would likely still have to come and tell us about what actually occurred. And there are other issues such as proving identification of the people involved and other elements that we would require the complainant to be there for. But it does in fact reduce some of the burden on the victim in their testimony, and that shift of the onus to the accused to prove evidence to the contrary is a recent development in our law. However, having said that, there are, as far as I can tell, none that I could find any reported cases that have dealt with this section yet, have used it or referred to its constitutionality, which means it's still early in the life of that section, but it is something to consider, particularly for the prosecution in relation to proceeding on these types of charges. And then before I turn it back over, I think, to question and answer, I don't want to go too over my time, but other relevant sections that have come into play that are similar in relation to the language and the type of actions that we are attempting to capture in these offenses came in after the Bedford decision, where they created a new procuring offenses, and these sections of 286.1 through to 286.4 created new offenses for procuring a person as well as receiving a material benefit from that procurement. And that 286.1 sub 1 in fact makes it now an offense to obtain sexual services for consideration or to communicate with anyone for that purpose. These new laws came into place, and it was a paradigm shift that prosecution was no longer viewed as a nuisance, but it was viewed as inherently exploitative, and it should be denounced and discouraged. So in these sections, they do provide that immunity to those who are going through these actions and receiving material benefits for their own sexual services or advertising their own sexual services. However, I don't know, and I wouldn't say it's as all-encompassing as Morgan had indicated, that maybe victims who are being exploited, which would be that all of the crimes they committed. But in relation to these, there is immunity provided to those who provide their own sexual services. But the difference in these sections is that requirement of proving exploitation is no longer there. So what you can see in the section, for instance, procuring, is that those same type, that language of actions for facilitating an offense under section 286.1, that the person recruits, holds, conceals, or harbors a person who offers or provides sexual services for consideration, or exercises control, direction, or influence over the movements of that person, would in fact be guilty of procuring. So these are just sections I'm bringing to your attention. However, for those of us in Alberta, it should be noted that there was a recent decision, Klubikov, I'm probably not saying that correctly, which actually struck down this, as well as section 286.2 sub 1, which is the material benefit section. However, since that time, and I understand that is under appeal at our Court of Appeal, the Ontario Court of Appeal has upheld these sections as being constitutional. So in relation to the types of offenses we are looking at here, and the law behind it, it is still developing, particularly as it relates to these types of offenses when we look to the sex trade working offenses. But going back to that human trafficking of 279, those cases are still going before the courts, and as indicated, unfortunately focus a lot on the complainants. So what we have seen a great development with, and particularly in working with Alert, is that in the world we are today, we see much more, hopefully, evidence available that can address and either corroborate or assist in the prosecution of these cases. That goes to the online presence of these services, advertisements of Leo lists and that type of thing that we are able to capture through investigation. There is also phone and internet type of activity that often can be used in relation to this. In some cases, we have seen videos and other type of CCTV or other type of recordings that can also assist. So it is as best as possible for investigations and prosecutions in these types of offenses to branch out in relation to the investigation and what other evidence surrounds these circumstances, to not just solely look at what a complainant or a victim is saying and to rest that solely on them. So that is also allows us then to look at the objective nature of that exploitation and be able to make a proper assessment when we look to those complainants and the offenses before the courts. So those are a very quick brief of what the law is currently. It's still developing in many ways, but I don't want to go over my time much more than I already have. So I'm going to lead it over to Kate to go back to the question and answer.
Thank you very much, Brina and Morgan. I was taking notes and learning a lot. So I will turn it over to our colleagues, and if there are not a lot of questions in the Q&A, then Brina and Morgan may have questions for each other.
So I just have a quick question here. I'm not exactly sure who wants to answer this one, but in section 286.1, obtaining sexual services, how can men constitute to buy sex at our body rub centers in Edmonton? So that's probably for Brina.
It would be an offense in relation to obtaining sexual services for consideration. It's whether or not the investigation and the evidence is obtained to prove it. But that is what is always the issue in relation to the body house question, and that's much of what was attempted to be rectified by the new provisions after the Bedford decision, but it's not perfect, I would say. But technically speaking, depending on how those sexual services are obtained, and if it could be proven that they would in fact fall under that section.
Okay, thank you. And there's a bit of a follow-up question to that as well. It says also in section 286.3, would advertising with the purpose of recruiting women to work in the body rub centers constitute procuring?
I would think it would. There's obviously, it depends on the circumstances. It's hard to just provide a yes and no answer to that question, and it depends on what the actual advertisement says, and what the employment, I suppose, if that's what it's going to be, if they're supposed to be, and these are the questions that go down the road of the concerns in reenacting these types of sections, was whether they are being considered as contractors, they're working for themselves, who is getting the financial benefit for that type of work. But it's kind of it depends, I think, answer, unfortunately.
Okay, thank you, Brina. We have another question for you. In Alberta, do the courts offer victim support services for providing testimony, such as testimonial aids, CCTV, or pre-recorded interviewing to avoid re-traumatizing them by putting them on the stand with the trafficker present?
We do have a number of different types of aids that can be provided and utilized within the court system for victims, depending on their age. I'll start first with the underage complainants. Underage complainants do have the ability to have their video recorded statement put into evidence. They would still have to be present in court, but pursuant to section 715.1 of the criminal code, that video recorded statement of the child would in fact be played in court, versus them having to recount all of the details themselves. And on a recent preliminary inquiry with an underage human trafficking victim, I had that same thing happen where she testified. However, she had the benefit of, we played her section 715.1 video, so she didn't have to recount everything. In addition to other types of aids, they are also provided the options of a screen and or the ability to testify remotely from a different room by CCTV. And that is becoming more commonplace, the remoteness of that due to COVID, but those applications existed before COVID, in that people could have a screen. People, I mean complainants and those who felt they needed that. It would shield them from seeing the accuser or the accused person in court, but they would still be present within the court, but they would not have to see them. We also have the ability for people to apply, and the Crown to apply for a support person. In some cases, support dogs can attend with people, and they can assist them and be present during their testimony. So there are a number of different options for aids for complainants that have existed for many years in the criminal law, and we do regularly use them if we can.
Great, thanks for answering that. There is a follow-up question from Morgane. Do you have any thoughts or policies on this in your area we could learn from?
Yeah, thank you so much for the question. Indeed, I would have touched upon the same examples broadly as Brina brought in. So for children, this is pretty common, but also we've learned a lot from the COVID experience. We did a global study where we reached out to a lot of practitioners in various regions where we work or countries that we collaborate with, to ask how frontline responders continued doing their work and try to identify and protect victims in times of COVID. And actually, this type of practices were very often pre-existent, as Brina mentioned in your local context, but much more being used much more during COVID times. And we think that it's a little bit like us, you know, having more and more online webinars. It's probably that a practice that now we've picked and that we will be seeing happening more and more often. Now, this is also something that had been implemented in situations where victims were foreigners and had been returned to their countries. So this is not necessarily a practice that's encouraged to return the victims before the proceedings go through, especially not returning them forcibly. As we advocate for voluntary return, but it's not always the practice in states. However, especially because victim testimonies is very often deemed to be really essential in many countries for the prosecution, there will be either a remote testimony or a pre-recording of the testimony. So even if the person is being returned, and sometimes voluntarily actually upon their request, their testimony can still be used. Very often what happens is that we may lose track of the victims once they return to their country, or they may not want to have anything to do with the proceedings anymore. So that's still a way to look into the situation of the person in their own words. Now, it also really depends on the jurisdictions, because it's not always acceptable in court. So that needs to be taken into account as well. In terms of policies, this is something that we've looked in more and more, and that states have also looked more and more into how, because we're talking about technology that can be a facilitator of exploitation, recruitment, etc. But it can also be an enabler to assist the responders in trying to address these cases. And so this is seen more and more as well, being used in every country and at every level, including in courts. So this is something that was included, for example, in recommendations of the working group on trafficking in persons that is taking place every year in Vienna, and which had a specific issue, a specific session on the use of technology in the context of human trafficking at the session that took place last year. And these recommendations are in turn presented to the member states and the states parties to the Convention on Transnational Organized Crime and the protocol to trafficking persons, so that it can be turned into a resolution that then becomes, you know, a political declaration and some things that's and some decisions that states can act upon and have to report on.
Great, thank you, Morgane. We do have another question for you as well. The issue of moral culpability of an offender who may have also been a victim is a very difficult one, as they would also seem to bear some moral blameworthiness for their behavior, particularly if their conduct involved violence or coercive behavior against others. How do you see the balance between recognition of their prior victimization and their conduct as an offender?
I fully agree with you, Shu. It's an extremely difficult question, and I think it's not only one that's present in the case of trafficking in persons, but also in other forms of crime, when the persons who are, for example, in pedophile offenses, when the person themselves have been abused as a child. What does it mean? I think the one of the let's say, it's not a safeguard per se, but one of the way to address that is to maybe separate the situations where the person is still being exploited when the offense happens, and the situation where this is, let's say, separate in time. That may be helping in addressing this issue, but it's true, and especially with Canadian colleagues, we've had extremely lengthy discussions on that, and I think this is because there's so many moral issues coming up, and also very different approaches depending on the cultures, the countries, the jurisdiction, that it's not it cannot be a blanket decision. It needs to match what is being done in regard to other cases as well, and the legal tradition. We see, for example, that in Argentina, the prosecutors are embracing more and more this idea, but there's also a real effort to work on the rehabilitation of victims, like this accompaniment of the victims and the avoidance of re-victimization also is really strong in their mind. So it's kind of a holistic way to see how to address the issue and how to best help victims. But yeah, I cannot actually, unfortunately, give you a more clear-cut answer than that, because indeed it has so many layers.
Great. Well, thank you very much, Morgane and Brina. We're going to wrap up the question part right now from our audience. If there's any outstanding questions, they will be sent to me, and then I can direct them to Morgane and Brina for follow-up later. But I wanted to just give Brina and Morgane just a minute to either add in something more that you think would help us all. And then I'll just come back on and wrap up. Thank you. Maybe I'll go to Brina first, about a minute, and then Morgane a minute, and then I'll take the last minute.
I'm not sure if I have anything more to add that I think would help us all. I think that even with that last question, it's something that it's something that we will all have to struggle with, and something in Canadian law that we consider at all times is what when it gets to a point of sentencing or moral culpability of an offender, we generally take that individualized approach and look to their own circumstances and how they got there. But also we have to consider the offenses and what their culpability was at the time. So as with everything, I think it's a case-by-case situation, and we always have to be mindful of the fact that we are dealing with people, and everyone is different, both on the offender side and the complainant side. So as much as we can, we have to consider those factors.
Thank you, Brina. Morgane?
Maybe I'll pick on something that Brina mentioned earlier, I think during a presentation, is that we see the law changing, we see case law influencing what's happening as well. We keep on learning on these offenses. We also keep on seeing the intersection between different types of offenses, the control mechanism that I mentioned. And I think it's changing for good. We're going in the right direction, and eventually we will see, you know, in the statistics and trends I showed you, eventually we will see the effects as well on these trends. We saw that it takes at least 10 years after a law is enacted to start seeing results in the prosecution of cases. So when children are being included, or some forms of exploitation are being included in the law, slowly you would see that actually the response is more appropriate, is broader, as it should be in terms of gender, in terms of types of exploitation. And that's something that we're monitoring and that we're accompanying states to do. And we really learn a lot from what states are doing, including in Canada. And we will keep an eye on that and keep discussing with all the practitioners about the experience, so that we can also share some of the good practices, promising practices, and discuss the challenges together with peers in other countries who are facing the same type of issues.
Thank you, Morgane. I would just like to say that I think it's very hopeful that we can have these conversations virtually. I've been getting up very early in the morning to listen into some of the European conversations, and that's where I heard Morgane. And I'm really pleased that we could have this Canada-Europe conversation today. I do see positive changes happening and understanding the complex areas of exploitation and trauma, and how we can uphold and protect the rights of those who are victims, understand the complexities for everyone involved. And I want to thank you both for giving your time today. This video will be posted on the Reach Edmonton YouTube page. You can see the link in the chat. We know many people couldn't attend today. Please share the link so that we can continue the dialogue in many ways. This event actually concludes the Edmonton portion of our Sexual Exploitation Week of Awareness. There are still several seminars happening through the National Victims of Crime Awareness Week. And I would just say, let's keep the conversation going. and commit to working to eliminate human trafficking in all its forms throughout the world. Thank you very much. Goodbye.
Thank you.